Judgment in the appeal, Marks & Spencer's plc and BNP Paribas Securities Services.
This appeal concerns 4 separate leases of floors in a very large building in West London, granted by BNP to Marks & Spencer, M&S, from 25th January 2006 to 2nd February 2018. It is only necessary to discuss one of the leases because all 4 involve the same point. Under the lease, the rent consisted primarily of a so-called basic rent of £920,000 odd, subject to periodic reviews. The lease provided that this rent was to be paid, and I quote, yearly and proportionately for any part of a year by equal quarterly instalments in advance on the usual quarter days. The lease also provided for the landlord to recover by way of rent, 1, a car park licence fee, 2, a fair proportion of the cost of insuring the building, and 3, a service charge in respect of services provided to the building. A clause in the lease entitled M&S to determine the lease on 24th January 2012, that's six years early, by giving BNP 6 months' notice, which was only to have effect if 1, there were no arrears of rent on 24th January 2012, the date on which the lease would have expired under the break notice, and 2, if M&S paid to BNP the sum of £920,000 plus VAT by that date. On 7th July 2011, M&S served a break notice. Shortly before 25th December 2011, it paid the basic rent due on that date for the period 25th December 2011 to 24th March 2012. On 18th January 2012, M&S paid the £920,000 required by the break clause. Accordingly, the break notice was effective to determine the lease on 24th January 2012. This case arises out of M&S's subsequent claim for the return of the apportioned basic rent in respect of the period from 25th January 2012 to 24th March 2012, on the ground that a term should be implied into the lease, entitling the tenant to such a repayment. Similar claims were made by M&S in respect of the car park licence fee, the insurance rent, and the service charge. The High Court held that M&S was entitled to such repayment. The Court of Appeal allowed BNP's appeal. M&S's appeal to this court is today unanimously dismissed for reasons given in a judgment by me with which Lord Sumption and Lord Hodge agree. Lord Clark and Lord Conworth each give concurring judgments. We confirm the well-established principle that 1, a term will only be implied into a contract if it satisfies the test of business necessity, or, which is often the same thing, it is so obvious that it goes without saying, and 2, that it is a necessary but not a sufficient condition for implying a term into a contract, that it appears fair, or that one considers that the parties would have agreed to it if it had been suggested to them at the time that they made their contract. Applying that principle to this case, it's well established that rent, whether payable in arrear or in advance, is not apportionable in time in common law. It is also clear that Section 2 of the Apportionment Act 1870, which provides that rent should be apportionable in respect of time, applies to rent payable in arrear. In our judgment, we confirm the correctness of the conclusion of the Court of Appeal in a case called Ellis and Rowbottom 115 years ago, that the 1870 Act does not apply to rent payable in advance. Given the clear general understanding that rent payable in advance is not apportionable, it would be wrong, save in a very clear case, to attribute to a landlord and a tenant who have entered into a very full and professionally drafted lease, which deals, among other things, with payments if and when the break clause is exercised, an intention that the tenant should receive back an apportioned part of the rent payable and paid in advance, if there is no express provision to that effect. M&S argued that it had paid the sum of £920,000, if it had paid the sum of £920,000 before 25th December 2011, BNP would have only been paid an appropriate portion of the basic rent on 25th December 2011, and that commercial common sense therefore mandated that it should be in the same position whether it had paid the £920,000 before or after 25th December 2011. While this may represent something of an anomaly, it does not establish that the contract is unworkable or that the result is commercially or otherwise absurd. The same conclusion applies to the car park licence fee and the insurance rent, but not to the service charge, because in respect of the service charge, there is a specific provision which contemplates repayment. Accordingly, M&S's appeal is dismissed. The court is now adjourned.